Getting started, so go ahead.
Perfect, thank you. This meeting of the Washington Advisory Committee to the U.S. Commission on Civil Rights shall come to order. Thank you all for joining us. To begin, I would like to acknowledge that regardless of where we are Zooming from, we are all on the land of the first people. The land I am living is that of the Coast Salish, the land which touches the shared waters of all tribes and bands within the Squamish, Tulalip, Muckleshoot, and Puyallup nations. Generally, here in Seattle, we are in the traditional land of the first people of Seattle, the Duwamish people, and we honor with gratitude the land itself and the Duwamish tribe, past and present. For the benefit of the public who have joined us today, I will introduce my colleagues and myself. I am Alexis Harris, the chair of this committee. The members of the committee who are present today are Tony Benengas, David DeWolf, Andrew Kaufman, Zan Nider, Conrad Reynoldson, Eric Schnapper, and I know we have other members that will join on after their teaching or work meetings. Other members of the committee are Kimberly Ambrose, Luz Faminda Carpenter, Judith Endigan, Gary Laughlin, John Safarli, Brian Screener, and Aaron With. We have a quorum present today and we'll proceed with the meeting. Also present are commission staff, Brooke Peary, Civil Rights Analyst, Angelica Trevino, Support Specialist, and Kelly McGrath, Civil Rights Intern. I'd like to thank you all for your time, your energy, and your insight in helping us organize and plan these panels. You all have been extremely supportive. The U.S. Commission on Civil Rights is an independent, bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws because of race, color, religion, sex, age, disability, or national origin, or in the administration of justice. In each of the 50 states and the District of Columbia, an advisory committee to the commission has been established, and they are made up of responsible persons who serve without compensation to advise the commission on relevant information concerning their respective states. Today, our purpose is to hear testimony regarding Washington state labor laws and legal practices that potentially prevent full transparency and accountability from any disproportionate use of force. Today's meeting will also include a period for public comment later on in the agenda, and there will be an opportunity for members of the public to share their perspectives and opinions. If you are a member of the public who has joined us online, commission staff will be messaging you to see if you would like to comment, so please keep an eye on your chat box. That's where they'll send the message. For the members of the public who are joined on the phone with audio only, you will be able to indicate with your keypad when we reach that point in the agenda if you would like to make a comment. At the outset, I want to remind everyone present of our ground rules. This is a public meeting open to the media and the general public. I want to remind everyone that this meeting will be transcribed from a recording for the public record. I ask that you please state your name when speaking. Panelists should limit their initial remarks to 10 minutes. If your Zoom or your WebEx is not muted, please mute it. Thank you. I'll flag you panelists when you have about a minute left so that you know that your time is coming to an end. After all the panelists have spoken, advisory committee members will have the opportunity to ask questions. In addition, written statements may be submitted to Brooke Peary at bpeery@usccr.gov by June 18th, 2021. Though some of the statements made today might be controversial, we want to ensure that all invited guests feel welcomed and do not defame or degrade any person or any organization. As the acting chair of today's meeting, I reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand. Any person or any organization that feels defamed or degraded by statements made in these proceedings should contact our staff during the meeting so that we can provide a chance for public response. Alternately, such persons or organizations can file written statements for inclusion in the proceedings. I urge all persons making presentations to be judicious in their statements. The advisory committee appreciates the willingness of all participants to share their views and experiences with this committee. I would now like to begin our meeting by introducing today's panelists. They will speak in the order by which I introduced them. We are joined by Professor Leah B. Vaughn with the University of Washington Law School, Professor Elizabeth Ford with Seattle University School of Law, Dulce Gutierrez, Washington State Labor Council, Mike Solon with the Seattle Police Officers Guild, and Pete Holmes with the City of Seattle. So we will begin with Professor Vaughn. Please take the screen.
Oh,
No,
How do I do that?
oh, no, I'm sorry. It was a joke. Just go ahead. Go ahead. It's your time to speak, please.
Thank you. Thank you for asking me to address this panel. The work that you're doing is vitally important, but before addressing you on the substance of the proposal, I want to make a few introductory comments and observations. Beyond the typical academic interest in this topic, I have a personal and lived interest. As you can see by looking at me, perhaps I'm a biracial person and the mother of a son who is perceived as I am as Black. I've had to give my son the talk and was deeply concerned about the number of times the police would follow or question my son in our neighborhood of Ballard in Seattle, Washington during his adolescence and early adulthood. The fear and stress that this induces in a parent cannot be quantified, but it has to be acknowledged, I think, in a study of this type. On the other hand, I want to acknowledge that it's my understanding that my grandfather was a Seattle police officer. My mother and her family lived in Georgetown, past Sodo, where he was stationed. And although they would often come up to Ballard to be with family, where they were all members of the Scandinavian community here. So my grandfather passed away before I was born, but both of my parents taught me to respect the police and appreciate the nature of their public service. I'm a law foundation professor emerita at the University of Washington, where I taught for 35 years. I've taught labor law, employment discrimination, administrative law, alternative dispute resolution, and neuroscience and the law. My research interests vary from domestic violence, sex harassment, internal union affairs, and so on. From 1999 to 2005, I was the secretary of the faculty at all three campuses for the UW and was point of contact for faculty grievances, kind of like the union shop steward for the faculty. I also supervised the grievance and adjudication system. I'm also the initial drafter of the collective bargaining law for the state's higher education employees. I represented unions before I started teaching in Detroit, and while there, I was also chair of the Teacher Tenure Commission. I'm a third generation Seattleite and attended Seattle Public Schools, Princeton University, and the University of Michigan Law School. So I've submitted a 39-page statement, which is far more nuanced than anything I will be saying here. I want to make three major points about collective bargaining, arbitration, and non-legal ways to address this. First, I'm going to note there is not much legal research on the particular matter of policing and collective bargaining or arbitration. I also want to note that the American Law Institute has launched in the last 4 years a project on policing, to which I commend the commission. So turning to my first point on collective bargaining, I would say in my review of the literature, I went through about a dozen articles, and again, there's not much. The consensus is that collective bargaining agreements or the process of negotiating a contract can at times interfere with the imposition and enforcement of norms against excessive use of force. You've got to be careful with that, though, for two reasons. One is I don't want to obscure the voice function of unions and its importance. Those studies look more at what's called the monopoly function of unions. The other thing I want to emphasize is that it's a kind of science G2I problem. You're looking at a bunch of generalized data, and then you're trying to apply that to individual, say, union settings. It's hard for me to speak generally because there are, hundreds of units of law enforcement in the state of Washington. And I think you've got to keep that in mind when you try to develop policy. So it's not likely, I would be appalled if it were the intent of the parties to negotiate a contract that seeks to violate the Fourth Amendment. It's more likely that in the implementation of the contract, that you run into trouble areas. The areas that were highlighted were delays in questioning involved officers and impediments to investigations. Second, the expungement of discipline records that prevent tracking individuals and our departments over time in their record of excessive force use. Third, a lack of transparency and community involvement in the bargaining process, particularly around discipline and discharge issues. And fourth, that departments and unions may be lax in the enforcement of norms. That is, all departments need to enforce these norms, and unions need to be willing to refuse to send non-meritorious grievances to arbitration. That's the consensus on collective bargaining. Literature's all over the place in terms of solutions. Some said, let's eliminate all bargaining on discipline and discharge. Others said, no, let's do that, but let's do it in a public arena like negotiated rulemaking. Other people, I think it was Fisk and I can't remember the second author, were saying, let's engage in minority bargaining. And by that, they meant dissident members of the union, the numerically smaller group within a union would be brought to the table in addition to the union and management. So there are a lot of solutions, okay? Second point, arbitration. Here, there is clearly a problem and a clear consensus. I recommend the scholarship of Professor Stephen Rusham at Loyola Chicago, who has probably studied this more than anyone in the country. But it's very clear that the parties' ability to self-select arbitrators, coupled with a high reversal rate, and I've got copious excerpts from his article in my statement, means that any norms that are established are often undermined in the arbitral process. So for example, he documented that about 52% of discipline or discharge is reversed. That's in contrast to a 4 to 8% reversal rate for other forms of agency appeals. The Washington, and Liz, I think, will talk to this, recently adopted a statute that would have a roving panel of arbitrators. I really don't think this is enough. First, I have profound diversity concerns. Let's be frank. In my world, arbitration is kind of the province of old white guys. And you don't see diversity in the panels. I didn't see anything in the legislation that addressed that. There was also nothing in the legislation that addressed any kind of record retention or the development of an institutional memory. Therefore, I propose, and I couldn't believe I came to this, something like the Michigan Teacher Tenure Commission that would review cases of discharge for police officers. You'd develop an institutional memory. You'd have a uniform standard across the state. And I would also recommend hiring staff statisticians and so on, so that you could actually keep a database and track things. Whatever the panel committee suggests, I recommend sunset provisions because we don't know what's going to work. And the scholarship suggests we don't know, and there's not much done. My last point is that you need to look at non-legal solutions. So there's a certain sense in which I feel this is kind of like throwing spaghetti in a wall. Let's see what's going to stick. I do enough science from the neuroscience work that there is a lot that you, I think, could draw from that. An hour before I went on, Janelle Nunez just published an article on scanning for bias, a neuroscientific response to policing with implicit bias. People are doing this research. It's great stuff. For example, start thinking about the fact that in terms of brain development, you're not mature cognitively in a judgment sense until you're 25. So maybe officers shouldn't start until they're 25. Robert Sapolsky, a professor at Stanford, has written extensively on aggression and community. Maybe we need to understand more fully how aggression works, how it impairs decision-making during risk as we draft laws and policies. He also points out that community is important, that part of this phenomenon is othering, how do we create community at the risk of people from the union side blowing me away? It's that perhaps we need to return to residency requirements. Now, I know Seattle is prohibitively expensive, but there's a lot of neuroscience research that suggests that if we're community and we don't otherize each other, this eliminates some of the problems. Also, that perhaps we need a longer educational process. My daughter just finished a 2 years master's in social work. I really don't see that postgraduate degree as much different professionally from policing. And in fact, she wants to do trauma care and work with the police in this area. Another area to explore is technology, particularly searchable national databases. And last but not least, I want to emphasize, as a labor lawyer, but a person who also ran a human resource system, it's your people. And the way you treat them with respect, the way that you bring them in, the way that you collaborate. I think that it's extremely important to ensure, no matter what you come up with legal recommendations, if people don't understand them, if people don't use them in the workplace, if people have not bought in, you can throw laws at this until the cows come home and it won't do any good. But I'm hoping that the committee can really come up with some things, because I would really like for my grandchildren not to have to worry about this. Thank you.
Thank you so much, Professor Vaughn, for linking the personal with the academic. That was a really great way to start off this conversation. Professor Vaughn.
Thank you.
I'm sorry, Professor Ford, you're up now.
Okay, thank you. So hi, everyone. Thank you so much for inviting me to give testimony as a part of this panel. My name is Liz Ford. I am a visiting professor at the Seattle University School of Law, where I teach a workers' rights clinic. But I think that you have invited me to bring a perspective from the vantage point of an arbitrator. And so first, because it's what arbitrators do, I'm going to start with some disclosures about myself. First, before teaching, I was a labor lawyer representing unions, and later an employer representative. In those contexts, I have not represented a police guild, nor have I negotiated a police contract. Currently, and for the past 10, maybe more years, I've served as a labor arbitrator. I'm a permanent member of the Federal Mediation and Conciliation Services panel, which I will refer to as FMCS, as well as the Public Employment Relations panel, which I will refer to as PERC. That's the state agency. And while I've decided several cases involving public safety employees, I have never been appointed by the City of Seattle or the Seattle Police Officers Guild. I have decided disciplinary matters in the police context, but I have never decided a case involving the on-duty use of force by an officer. So, disclosures. My comments, again, because that's what we do, we'll touch on 3 areas. First, I want to give you a little context for collective bargaining in Washington and how arbitration fits into that. And then I want to talk a little bit about some developments in the law in Washington. Leah made some reference to it, and I'll fill that out just a little bit. And then I would, if there's time, and I know that you're very serious about the 10 minutes, I'd like to close with some suggestions of areas of inquiry. And I'll try to give you some as I go along as well. So first, context. I want to start with a quick clarification of the collective bargaining laws applicable to police in Washington. At RCW 4156, which is the Public Employment Collective Bargaining Act, is the statute that establishes collective bargaining between counties or cities and the unions that represent their employees. The project proposal that was distributed to panelists in advance of this panel cites to RCW 4180, which is the state law that applies to state employees. So except with respect to a small group of state employed police officers, state patrol, some other small groups. The correct statute is 4156. And 4156, among other things, requires bargaining between the employer and the union on wages, hours, or other terms and conditions of employment, right? That probably sounds familiar to you. The existence of a grievance procedure culminating in binding arbitration is one of the subjects on which bargaining is required. However, there is no statutory obligation that a collective bargaining agreement include arbitration as its dispute resolution mechanism. The statute, now I'm talking about 4156, explicitly contemplates the possibility that the parties could use a public body, like a civil service commission, as the final step in its grievance process. And in a provision that might be unique to Washington, the statute, and again, 4156, exempts from bargaining, and here I'm quoting, any matter which by ordinance, resolution, or charter of said public employer has been delegated to a civil service commission or personnel board, similar in scope, structure, and authority to the board created under Chapter 4106, which is the State Civil Service Commission. That statutory provision has been interpreted extraordinarily narrowly by the Supreme Court, which has sort of limited this exception to bargaining to circumstances in which the civil service commissions are identical, which is why in a contract, I think, in many police contracts, you'll see alternative forums, civil service commission or arbitration, civil service commission and arbitration. So it's an interesting opportunity to perhaps clarify a law. Okay, so context. Now, the process leading to arbitration. Presuming that the parties have agreed in their collective bargaining agreement to grievance arbitration, there's a pretty standard set of expectations about how that process works. Though, again, its features are subject to bargaining. Generally, there are a series of grievance steps that precede arbitration. These are essentially a chance for the union to, for the parties to meet at increasingly higher levels of management authority and try to work it out, try to resolve the grievance. And if the parties fail to reach that agreement, often the last step is binding arbitration. If the matter, the grievance, proceeds to arbitration, the arbitrator is selected either through agreement by the parties, if they pick a person, or through a process of striking names from a list provided by the FMCS or the American Arbitration Association or PERC. And so that process looks like this. FMCS provides a list of arbitrator names. It's generally an odd number, like 11 usually, or 9. Each of the parties then proceeds to strike the arbitrator name that is least acceptable to them. And they go through that process, ending up with a single name. And so it's important to note here how that FMCS is a important gatekeeper for the universe of arbitrators, right? FMCS imposes some of the basic requirements in order to be listed and provides a set of ethical rules for arbitrators. I'll talk about those in a second. In addition, the National Academy of Arbitrators is sort of a smaller subset of that same roster of people, and National Academy has a slightly more rigorous set of criteria to be listed. And the National Academy has also developed an ethical code for arbitrators. Those codes require a couple of things I want to point out to you because I think this is another area that merits the Commission's focus. They require arbitrators to maintain the proceedings of the arbitration private unless the parties agree or the law requires otherwise. There's a question in my mind as to whether those requirements apply only in the private sector, since public sector decisions and records of proceedings would be subject to public disclosure laws, but there's no explicit exemption there, nor is any kind of explicit exemption related to the arbitration of police disciplinary cases. So in any case, looking at these gatekeeper functions and these professional codes, I think, is a worthy expenditure of the Commission's energy.
Just want to know you have two more minutes left in your time.
Okay, so let me, I'm going to say two last things. Let's see, that there's a set of well-developed arbitral principles that govern the determination of whether an employer has just cause to discipline or discharge an employee. I'm not going to repeat those here, but here's the fundamental idea. The collective bargaining agreement does not change who has the authority to make the disciplinary decision. That authority rests with the employer. The just cause provision places the burden on the employer to demonstrate that it did it fairly, thoughtfully, and in an accurate way. I commend though I don't have time to talk about it, I commend your attention to a set of cases, arbitral precedents having to do with off-duty officer conduct. I think this is a very important area in which the arbitration decisions lag the reality. And so it could be an area of intervention that could make an enormous difference. I think the cases, I could point to my own as examples of this, in that area are progressing, but the arbitral decisions that have been issued thus far are troubling. Finally, the materials that were given to panelists prior to this presentation made reference to a decision by arbitrator Wilkinson reinstating a City of Seattle police officer who broke the orbital bone of a suspect. In a hugely important and, in my opinion, correctly decided decision, that arbitration award was vacated in, I think it was mid-April. The court found that the right to be free from excessive force, which finds its source in the Bill of Rights, is enforceable against states by the 14th Amendment, is an explicit and dominant public policy, and as the result, in Washington at least, an arbitration decision that reinstates an officer who has engaged in excessive force should be overturned. The Washington legislature in most recent session enacted the Law Enforcement Disciplinary Grievance Arbitration Act. I commend the Commission's attention to that and study of that. I think Leah is correct that it makes some progress, especially including the fact that PERC will be the appointer as opposed to the agreement of the parties. And I also agree with Leah that could go further. The last thing I'll say is that I would encourage the Commission to think about ways to make arbitration processes public. So including public hearing, so inviting the public into the actual arbitration hearing, could do nothing but expand legitimacy of the outcome of that hearing, make the decisions public and easily searchable. So much like judicial decisions are reported, creating some kind of reporting series for decisions, which requires an amendment to the FMCS rules that an employer must extract permission from the parties before making their decisions subject to publication. I'd love to talk more about it. I know my time is up. Thanks, everybody.
Thank you so much, Professor Ford, and we'll have time for question and answer. And I know you didn't get to talk much about the development in the law and the areas of inquiry, but I'm sure one of our committee members will ask you about that, and you can use time. So thank you very much. Our next presenter is, I thought I saw Dulce Gutierrez with the Washington State Labor Council. Are you prepared to speak? Okay, we'll move on right now to Mike Solon with the Seattle Police Officers Guild and circle back. Mr. Solon, are you prepared to speak?
I am. Thank you very much for having me. It's an honor to be here. I appreciate everybody's time. Can you hear me okay? Okay, yes, perfect. I've been a police officer for over 21 years in the city of Seattle. I was thankful that the city took a chance on me, and I've served the citizens well. My profession, I get aspirations in that 21 years as I was a patrol officer for a number of years. I worked third watch, particularly in the South Precinct, which is the Rainier Valley. And then I moved on to a detective in the department's gang unit. And then I moved on to the full-time Seattle Police SWAT team for over 15 years. I've also been involved with the union, which is the Seattle Police Officers Guild. I'm their current president, elected by the membership. I've been in this position for a little over a year. However, I've been a board member with the Seattle Police Officers Guild since 2013, was elected as their vice president in 2019, and then took the president role, as I mentioned earlier, not too long ago. A third of our membership are persons of color. We have transgender, LGBTQ. We have Native Pacific Islanders. We have Native American. You name it. We are a very proud representation of Seattle's values and the diversity of our great community. And we initially had 1,300 members, but as you can see in a lot of the headlines, we've lost a significant amount of officers. The scope of the past over a year, we're almost down to 300 people, which has significant public safety implications that are detrimental to our community. We are fully supportive of reform, as our members have participated in that reform process in the decade-long endeavor with the Department of Justice settlement agreement agreed upon by the federal government, Department of Justice, and the city of Seattle just over a year ago. And frankly, around this time, if you will, our mayor of the city of Seattle and our president of the city council publicly applauded this agency as being that model of reform that other agencies across the nation should emulate, credit the work of the men and women that do the job of policing, that led the effort in reform. We're a model of reform when it comes to de-escalation. In fact, this agency, I believe, since a long time ago, around 2008, have been strategic and been very progressive and forthcoming in their training modules relative to de-escalation practices, along with crisis intervention, where we've partnered with mental health professionals and developed a robust program that I believe other agencies have looked upon as being that model crisis intervention platform as far as de-escalation issues and tactics are concerned. In terms of the collective bargaining agreement, as Professor Ford was correct in saying that we follow the RCW 4156, and we adhere to that, and our bargaining endeavors are with the city of Seattle, and we are currently in an expired contract. And for several decades, we've partnered with our accountability partners and welcomed that type of civilian oversight in terms of our accountability partners with community buy-in and having a say in our collective bargaining aspirations at the bargaining table. As you can recall, in 2007, 2008, there was a police accountability blue ribbon panel birthed in the city, and that panel made 29 recommendations. All of those recommendations were absolutely accepted by the Seattle Police Officers Guild. And in fact, there was only about 3 or 4 that actually had implications when it came to collective bargaining. And those were adopted and accepted by the Seattle Police Officers Guild and the city of Seattle in the form of a memorandum of understanding in 2008. One in particular is regarding the recommendation number 11 from the 29 blue ribbon panel recommendations, is the Office of Police Accountability, which is the same entity that was Internal Investigations at the time. That entity was the primary link between the community and police accountability. And in doing so, the police accountability were to hold public meetings, hearings, and opine on complaint, investigative procedures. They would intervene and inquire into specific investigations, the ability for the public to comment on those investigations, particular individual cases, and issue reports in individual cases or identify individual officers. In the furtherance of partnering with our police accountability partners, in the 2014 now expired contract, the city of Seattle enacted the accountability ordinance. And as Professor Ford talked to earlier, as far as working conditions, anytime you change a working condition issue that touches on the collective bargaining, because we believe that police are labor, much like any other public sector unit or entity, if you will, any change in working condition is a mandatory subject to bargaining. And so if it impacts an officer's ability to do their job, in particular when discipline is conjoined with that type of ordinance, well, we believe and we firmly have a stance that you have to bargain that mandatory subject to bargaining. Otherwise, if we didn't, then there wouldn't be a point of having a police union. As I mentioned previously, that police are labor and we have a right to RCW 4156. So in terms of the accountability legislation, we in fact accepted most of the accountability legislation in that now expired contract. In fact, we had reopeners to discuss those issues that the accountability legislation / ordinance targeted. The reality is we did not have to do that because it is indeed a mandatory subject to bargaining and the city would have to approach us at the table. But we took it upon ourselves to bring that forth into the contract, because if you're well-versed in collective bargaining, at your opening offer, when you're at the table, you have the city's opening offer, then you have the union's opening offer. And at some point within that first initial meeting, that an opening offer, those opening offers on both sides, you can't add anything else. Well, we fast forward several years later when we were finally getting momentum into good faith negotiation with the city, we decided and made the decision to absolutely welcome some aspects of the accountability legislation voluntarily so we can continue our partnership with our accountability partners. We didn't have to do that because we were following RCW 4156 collective bargaining, but we indeed did. And in terms of the history of certain aspects of people saying that all police unions do is protect bad cops, well, that's absolutely incorrect. And in fact, the last 5 terminations relative to several years, this entity has not granted a discipline appeal. And quite frankly, in the term that I've been a part of this union relative to a hyper focus on police unions and arbitration issues, there's really only one aspect of an appeal in terms of arbitration where the scope of Professor Ford spoke of is the Adley Shepard case. And I'll probably be as brief as possible with that because we are appealing to the Supreme Court for that case alone. But I don't see any other issues that target that type of hyper focus in terms of Seattle Police Officers Guild in relation to good faith negotiation with the city of Seattle when we talk about arbitration. I'm happy to continue this discussion in the Q&A. I want to thank you for your time and particularly the opportunity to be here. As I've said many times, that I'll speak with anybody at any time, as long as it's a reasonable discussion. And the fact that this panel is an absolutely reasonable discussion, and I'm honored to take part. Thanks a lot.
Thank you so much for sharing your perspective. We appreciate it. And now we will turn to Dulce Gutierrez from the Washington State Labor Council to speak. Are you on mute?
Dulce has written in the chat that I can't hear anything.
Hi, everyone. Can you hear me?
Good.
Yes, we can. Thank you.
Okay, great. I wasn't sure if I was unmuting myself on both devices or just one. But good evening, everyone. It's a very great and wonderful pleasure to be here with all of you. My name is Dulce Gutierrez, as it was stated. I am located in Yakima, in Central Washington, and I have the pleasure of being an accredited representative, working on immigration cases for the Washington State Labor Council and union members across the region here in Central Washington. I was also able to have the wonderful experience of serving the city of Yakima as a council member and as the deputy mayor as well. my term ended at the end of 2019. And so I wanted just to say thank you for this opportunity to talk about this. I have, you know, a couple of different perspectives, and I'd like to share the two ways in which I've interacted with this area of work. So first and foremost, it's really important as somebody who's in the labor and in the labor organization and the labor movement to emphasize the importance of having equal protection across the board. So for labor advocates, we have not pushed for the creation of a double standard of protections, specifically making modifications to who does and doesn't have qualified immunity working for government. And so we've been very careful in trying to preserve and being very intentional to trying to preserve protection across all sectors and all different lines of work for workers. And so that is, you know, not an area that has been the point of conflict so much, because we see this as something that could affect labor laws that affect other workers down the line. So it could become something that, while we have good intentions, may have lasting impacts that could harm other workers and labor laws. But we have focused on accountability and for government officials, and also upholding civil rights, and really advocating with this in mind and having this at the forefront of our organizing. We have supported different legislative bills that continue to increase transparency and separate as well the levels of government when a incident of excessive force happens, you know, trying to create some level of separation between the incident itself and the immediate department in which the incident has occurred. It has become more and more common to see task force being created to review a case that may happen, and some of these task force are regional as well, which really creates you know, far more trust in the process by the public, as opposed to having internal investigations. And so we have continued to advocate for this, but you know, we have worked with police unions quite closely at different levels across the state, and trying to work with the police officers around their own scope of work, and what is it that good cops and cops need when they, you know, find themselves in a situation where they have witnessed misconduct. Are they in a department where the environment is safe for them to make a report, or will there be retaliation? And while we don't really necessarily know the ins and outs of every single department, my experience in the city of Yakima, having served 4 years, oversaw many different areas that were problematic with the way the police department itself was being administered. And it really went from the top to the bottom, or from the bottom to the top, whichever order you'd like to look at it. But there were issues happening out in the field that were very difficult to correct or remedy. And there were issues happening at the highest level of the administration that were also very extremely difficult to correct. And so we were dealing with an issue that I think a lot of other cities may have found themselves at some point dealing with. And that is that while you may be a full service city with 10 or more city divisions or departments, the police department and the employees within the police department are treated very differently in comparison to all the other divisions and departments, including the firefighter department. And so accountability becomes a very difficult thing to deal with. And a lot of issues, you know, can be dealt with internally, but it becomes very public, and things become very difficult to manage and administer internally to fix things before they snowball into something worse. when there is conflict between the police union and the city administration, be it the mayor or city manager or the city council. It becomes very difficult to do sometimes what is best for the city budget, do what is best for the greater community sense of security, when there are very difficult standards and expectations to meet that are agreed to during the negotiation process with the police, but oftentimes things are agreed to because city administrators or city leaders do not want to face essentially a public backlash for not agreeing to what the police say is needed. And so it becomes very difficult to find a balance. And, you know, people say, some people in the public feel like there is a barrier that is the police union in creating better accountability or having a more balanced and transparent department for the public. But I would push back on that. I don't believe that it is the union. I think that it is we need a much larger conversation about what the laws themselves allow cities to do and what the laws at the state level preempt cities from doing. And we can go as far as the federal government laws as well and how far they are intertwined or involved with local laws. But in reality, that's really where I see a greater need for there to be action taken. There needs to be more legislation at the state and federal level because there's going to be a long, long waiting for the public to find any real substantive change. And even some police officers themselves want some substantive change. It's very difficult to get that without there being a huge exchange in terms of, you know, what the police department or the police union would like to negotiate on behalf of the city. And I want to give you guys a specific example. In the city of Yakima, we have dealt with different excessive force issues. We have dealt with a high crime rate. And so we continue to put resources into the police department. And with the police department itself has asked for greater resources. For example, they each have an assigned vehicle. They get to take their vehicle home. They don't have to live in the city of Yakima to have their own vehicle. They can live anywhere they want, and they're encouraged to drive their vehicles wherever they want. Now, we pay for all their fuel and their taxes, you know, with our tax dollars, and we don't take really even into consideration in accounting for how much mileage is being used while they're not on the clock. But we do this. And we do this because cops negotiated through the negotiating process. This is something that they thought would be helpful and increase the sense of safety because the public would expect that there would be, you know, more cops on the road, even if they don't necessarily know if they're on the clock or not. Well, we have found ourselves to be in a situation where now the public is under the impression that lots of cops are on the road and no one's helping them when they call 911. And they don't understand why cops are driving past them after they've called 911 instead of helping them and driving to them. And it's because the cops are not on the clock. They're just driving the cop vehicles to the gym or to the grocery store to drop off kids at their schools. And so what happens is that we find ourselves in a situation where we are able to meet what the cops want, but when the cops don't want body cameras, we can't budget for body cameras. So you have then all of a sudden, or even some dash cameras. So all of a sudden you have officers who who are able to present themselves, whether they're trying to do it intentionally or not, as officers of the law. They might not be on the clock, but they're in a cop car. They get in an altercation with somebody if they see something in the public, and we don't really know what's happening. So my point is that we are providing resources. We are trying to meet the needs of the police departments, in large part based on what the unions negotiate for them. And we can't really find a balance to ensure that all of the resources that we invest into our police departments are coming with strings attached that really increase transparency and accountability. And we find ourselves in situations where we're continuing to invest more and more based on what the workers need, which in this case is the cops. But the people on the receiving end of the services, their voices aren't really taken into consideration. And so,
less than 1 minute left. I'm sorry to interrupt.
I have less than 1 minute. Thank you. I'm concluding. So this becomes institutionally problematic because, and that's just one example. We could talk about, there's been scenarios where, officers are not clocking off and they're, going home, coming back. And so there's a lot of things happening. What happens is at the end of the day, the city leaders want to meet these cops where they're at. We want to make sure that they feel supported and protected and defended by city leaders. But it becomes very difficult when there isn't a mutual understanding of what everybody needs, and there is a far more imbalanced relationship and dynamic that is oftentimes exacerbated by the public sense of desperation for greater public safety, which is understandable. But it is important in that case for the state to take action. It is important for the federal government to take action, because while we all wait for city leaders to take action, we're going to find ourselves waiting for a very long time. Thank you
so much. Thank you so much for that. I'm sure we're going to have a lot of questions for you to engage in the next section. And now we turn it to Mr. Pete Holmes from the City of Seattle.
Thanks, Professor Harris. Thanks all the members of this committee. I am grateful for the work that you're doing for the National Commission, and I'm glad to participate. I thought I'd just give you a couple of quick remarks about my background. A short trip through memory lane about Seattle's consent decree, and I'll try not to repeat anything that's already been touched on. I am looking forward also to engaging in Q&A after the presentation. I am now in my 12th year as the city's lawyer. I, however, am neither an employment lawyer nor a labor lawyer. I was a civil commercial litigator for a number of years before accepting an appointment for the very first panel way back in early 2002, so nearly 20 years ago, to the city's first police oversight board, the OPA, the Office of Professional Accountability Review Board. It was in that experience, as a privileged white male, never having had difficulties with the police, that I really came to look at the importance of police reform. I think it helped me to help face my own prior background. I grew up in Central Virginia, 19 miles from Appomattox, and starting to try and understand better the frayed social fabric, for want of a better phrase, that we live in today. I ran for office in 2009 and was elected to my first term in office. And it was in that very first year, 2010, that a Native American woodcarver named John T. Williams was shot to death by a Seattle police officer. Shortly after that, some 34, I believe, community organizations signed a letter to the Department of Justice demanding a patterns and practices investigation that ultimately culminated in a finding by the DOJ that SPD had engaged in a pattern and practice of excessive use of force, wherein over 20%, that 20% of the uses of force exceeded constitutional limitations. They were DOJ was especially critical of SPD's use of force against individuals experiencing a behavioral health crisis. And they also found that when SPD officers detained people for an investigative stop, a so-called Terry stop, that they were more often stopping people of color, and that those disproportionately escalated into uses of force from an initial stop. And the DOJ laid the cause of all of these problems to inadequacies in policies, training, and supervision. So in my first term, we did enter into a consent decree that is still in place today with the Department of Justice. In fact, Judge Robart, who oversees it, and I are the only ones that are still in our same positions as we were back in July of 2012 when we entered into the consent decree. Now, under the consent decree, it's really important that we talk about what's been accomplished. To address the problems that DOJ found, our consent decree focused on the new reform policies and training, and did a great deal of work over the ensuing years. The DOJ did not find that SPD's accountability system was in need of reform or repair, and yet in the same period of time, SPD and the city did give greater strength and powers to the Office of Police Accountability, formerly known as the Office of Professional Accountability. It created a new Office of the Inspector General, and then the Community Police Commission eventually became the replacement for the panel that I was originally appointed to back in 2002. The Community Police Commission replaced the OPA Review Board in essence. And so with all of those policies, trainings, procedures in place, and with this new accountability structure in place, it was by the end of 2017, roughly, that the monitor that was appointed by the court to oversee the reforms under the consent decree had found that SPD had reduced its serious uses of force overall by 60%, and that because of the crisis intervention training, it was really incredibly rare. It was down to single decimal points, the uses of force against people in crisis. And then finally, the monitor and DOJ have gone back to review how the progress to date of SPD. But what's important to bring us to the present is first, not what happened over last summer, but rather what happened in November of 2018. There were two critical events then. Number one, the city did enter into the current collective bargaining agreement with SPOG. The executive negotiated that contract. It was presented to the city council and ratified by a vote of 8-1. The other thing that happened was that an arbitrator overturned a firing of a police officer, Adley Shepard, who had fractured the orbital bones of a suspect who was intoxicated while she was handcuffed lying down on the back seat of his car. But back at that point in time, in early 2018, the city had been found to be in full and effective compliance by Judge Robart. But by that November, and before my office had taken an appeal of that arbitration award, the court found that we had fallen out, that SPD and the city had fallen out of compliance. And in fact, at the pivotal hearing, those of you who may have been present here, the judge showed the entire video clip of the suspect being injured by Officer Adley Shepard in the backseat of his car for the entire courtroom to see. So it's that brings me now to the fact that by early 2020, we had indeed we had maintained in the city's position a 2-year sustainment, full and effective compliance in January of 2018. By early 2020, the city had filed a motion to terminate the sustainment plan because we had maintained full and effective compliance in the city's view for 2 years. And yet just following the murder of George Floyd in Minneapolis, something happened in Seattle. That motion that I had filed just weeks earlier, in early June, I withdrew the motion from the court, and that has been indefinitely suspended. And at this point, we now have a brand new monitor whose job has been to put in place a monitoring plan to determine the status of SPD's compliance today with the consent decree. And in particular, they're looking into issues about the crowd control and management and the uses of force. And it's an undertaking that will be with an interim police chief in place. As you may know, this is an election year. Seattle will be selecting a new mayor, and then and 2 at-large members of council, as well as my position. And then starting next year, we'll hopefully have received some indication from the monitoring team about its assessment of SPD's state of compliance with the consent decree. We'll be simultaneously launching a new police chief search, and it's going to be an interesting time. So my point being that the work of this committee could not be more timely. All eyes are focused on Seattle, and there's a lot facing ahead as this community attempts to reimagine policing. And the impact, I'll close with this by saying that even though I don't negotiate the contract, I do provide advice, I do enforce the contract. And that means both the decisions that chiefs and mayors make under the consent decree, but it also means insisting that the city comply with its contract. I'll close by saying that I delivered a keynote address to the National Association of Civilian Oversight of Law Enforcement in Boise a few years ago. And at the time, there was a push to open up collective bargaining itself. We've talked here today about opening up the arbitration proceedings, but there was a point in time when they had asked to do that. And I pointed out then that the collective bargaining agreement is a legally binding contract, and the ground rules that are set for negotiating it are ones that we have to follow. We will follow the law. When the law needs to be changed, I have advocated in Olympia to do so. But the collective bargaining agreement, this city will comply with all of the bargaining rules with the state law. And it's going to be an interesting concept to see as we reimagine policing how issues like wages, hours, conditions of employment, and things like body of work are going to impact the city trying to articulate and put into place its vision of policing going forward. So with that, I think I'll stop.
Thank you so much, all of the panelists, for providing your personal experience, your professional experience, laying out the timelines and the key issues. We have been looking forward to this panel since the inception of this idea that we wanted to focus our series of hearings. So we are excited to engage with you. We have a little less than 40 minutes. We'll now open the discussion to the committee members present to ask questions of our panelists. I will address each committee member in roll call style so that each member will have the opportunity to ask one question and a follow-up. So committee members, please keep your questions brief so that everyone can get an opportunity to engage. Please wait for your name to be called before asking a question, and if time allows, additional questions will be permitted. In the event that there is time for additional questions, please use the raise your hand function to indicate that you would like to speak, and I'll call on you to address the panelists. So I'm going to just do the roll call according to the videos that I see in order. And I'll begin with Andrew Kaufman. Do you have a question that you'd like to ask our panelists?
Yes, thank you very much. I have a question for Mr. Solon, if he's there. Are you there, Mr. Solon?
Yes, I am. Thank you.
So I'm just curious, from your perspective, what kinds of reform with respect to arbitration proceedings or just generally would you support? Maybe a specific question or example would be there's talk about making the arbitration proceedings more public. Would you support a move in that direction? But you can speak to that specifically or just more generally.
I mean, I think it's rather general specific. It's the same, the same, and I appreciate the question. The reality is that the purveyor of an entity that speaks on behalf of the Seattle community is the Community Police Commission that City Attorney Pete Holmes alluded to. And in fact, a representative from the Community Police Commission will be in the next round of contract negotiations. So there's that community aspect. In terms of the city's interest, well, as we know, the mayor of the city of Seattle, and obviously as City Attorney Pete Holmes spoke of as well, is that there's going to be a new mayor, and the mayor appoints members of her administration to partake in the collective bargaining negotiation process, as well as the city council as well, who are elected by our citizens. So you have the mayor, the city council, they're allowed to have people in the negotiation room as well as the Community Police Commission. So we welcome that, and we look forward to future contract negotiations with the city.
Thank you. Andrew, do you have a follow-up?
Well, yeah, I guess just directly. So are you suggesting that you're open to reforms, you're open to negotiations, but you don't have a specific reform idea that you would support?
Well, I think that the fact that our membership has participated in the 9+ years reform process, and we are indeed still spoken of as being that model agency of reform, is reflective to us being consummate public safety professionals, that we're always in search of reforming and honing our skills in the service of our community. In terms of a specific reform concept, I think I need a more focused question to what your, I think, interpretation of reform looks like. It's my understanding that the purveyor of what reform looks like is indeed the Department of Justice, which is still obviously in the agreement with the City of Seattle and Department of Justice, as City Attorney Pete Holmes alluded to. And obviously the overseer of the final process to ascertain whether or not we have indeed met all the benchmarks is the federal judge. But the purveyor of what reform looks like for a constitutional modern day policing entity is the Department of Justice. And just days before Floyd, as our mayor and our city council president pointed out, that we are indeed that model agency of reform in their endeavors to terminate the settlement agreement, the Department of Justice agreed. But here we are after Floyd, and we're still under settlement agreement, which is fine. We'll continue to work on behalf of the citizens as we serve the community's will, and we'll continue to put the work in towards the march to reform, because we're consummate professionals and we're dedicated to our profession.
Thank you. Just to clarify, when you reference Floyd, are you referencing the killing of Mr. George Floyd?
Yes, ma'am, George Floyd, yes.
Okay.
Because City Attorney Pete Holmes brought it up, so I thought it would be appropriate to opine on that position as well.
Thank you. Brian, do you have a question?
Yes, I have a question. Thank you, by the way, Chair Harris and all of our panelists. I appreciate your time in speaking and informing to us. I have a question for Elizabeth Ford. Thank you for your comments. Mine have to do with your thoughts on the viability of reducing the authority of arbitration to overturn disciplinary actions against officers. And secondly, how do we, police unions frequently advocate for shielding disciplinary and behavioral records from public view, and often mandate destruction of these records. Are these two questions that are viable in looking at legitimate reform, both here in Seattle, across the state, and then broadly for police departments as part of the labor negotiation process?
Oh, as part of the labor negotiation process. Okay.
Or any process.
Okay, or any process. Okay.
Well, I mean,
right,
I do think that the labor negotiation process is important, because this is ultimately where we're trying to get focus on. But broadly, get your thoughts on those questions.
Yeah, because so your first question has to do with the viability of reducing the authority of an arbitrator to overturn the management's decision.
Correct.
Right.
Yes.
Okay, so let me offer two possibilities. One has to do with switching out the arbitration process for a more public process. So the reason I raised the possibilities of a civil service commission being consistent with the within the realm of options at the bargaining table was to sort of start you thinking about that and the pros and cons of that. Having simply the absence of a final decision maker, right, on questions of discipline and discharge, effectively would mean that we would be sort of excising that just cause provision from the contract. So that's a sort of a different level of decision that I would want you to think very carefully about, because really all you'd be doing by eliminating the just cause protection is switching the allocation of authority from to more toward management. And so the problem, I think, fundamental problem is equally should be, is primarily did management address adequately the misbehavior, and then does an ultimate arbitrator's ruling affect that? So I suppose at the very end of the options are, you could just get rid of just cause altogether. Slightly further in, you could say we want a different forum. Civil service is an option. Slightly further in from that is the question of the arbitrator's authority to reinstate. And so that's why I raised the very recent Court of Appeals case in which Washington has said that an Arbitrator Wilkinson, does not have the authority to reinstate a police officer that has engaged in the unreasonable use of force. That's new, and I think really worth studying. It is true that, as Mr. Solon says, this has not yet been appealed to the Supreme Court, and I'm certainly not going to predict, though I do, the judge that wrote the Court of Appeals opinion is quite well respected, and the opinion itself is quite strong. So hopefully that gives you some ideas. And then your second question has to do with sort of these sometimes called sunset provisions, sometimes, about how long the disciplinary records remain recoverable, discoverable. And that, I think, is a collective bargaining question, right? Changing that. Some states have law officer Bill of Rights laws. We do not. So to the extent there are those kinds of sort of limitations, they exist in the collective bargaining agreement. So the question of negotiating a change to that has to do with the willingness of the employer to take the issue to interest arbitration.
Brian, do you have a follow-up? Oh,
no. Thank you. I appreciate it.
Professor Vaughn, would you like to reply?
Yeah, I wanted to add a little something to what Liz just said. It's pretty traditional in arbitration law that arbitrators are limited to the extent they consider external law. So this Washington decision is really, really important and groundbreaking. And it might pave the way for arbitration or whatever we do in the state to be more useful if it requires a consideration of Fourth Amendment excessive force law as part of making a part of the decisional process above and beyond the collective bargaining agreement. And second, as to the records and retention policies, I'm just going to say, as a public employee, my records are kept forever. There's still a file over there at the U, like this thick, right? Or, probably like that. Yes, it's a subject of bargaining, but there's also state legislation about records retention. You're also going to have to take a look at the Washington State Public Records Act, which does have an exemption for personnel records. So even if by law we decide they should be retained for a longer period of time, you also need to check into as I said, the personnel exemption. Thank you.
Thank you, Professor Vaughn, for adding that. Thank you.
Thank you very much. I appreciate it. David, you're up next.
Thank you. My question is for Pete Holmes, and it has to do with the 60% reduction you referred to in the cases of excessive force. And I'd like you to expand on what that was attributed to and whether it represents a vein of ore that has been exhausted or whether there's more that could be done along the same lines to reduce the cases of excessive force even further?
You bet, David. Thanks for the question. I think that a deeper dive into the fuller policies that the city developed over the course of the years under the consent decree is really a longer discussion. But I would highlight some of the major points. The de-escalation policy, for instance, and training to make sure that officers were trained. You probably heard some of the discussion that was going to the moving toward the guardian model of policing as opposed to the warrior model. I think that they have tried to inculcate a lot of these policies based on best practices and based on the data that supports ways of actually helping to protect both the individual contacted by the police as well as the police themselves. Stepping back and studying and understanding what led to a violent outcome. The processes internally, I already alluded to the Crisis Response Center, that helped. But internally, they have a force review board at SPD. It hasn't been functioning really during the pandemic, but where every serious uses of force were broken down into 3 levels, types 1, 2, and 3, depending on the severity of the force used. And everything above de minimis force requires that a report be issued by the officer using force, that it be reviewed by his or her sergeant, and then it's reviewed by the force review board for all to see, with the video, with the CAD calls, all those things put on display in a setting with a number of experts sitting around from within the department, monitored by the monitor, by DOJ, by my office, and just actually taking back lessons learned from uses of force that escalated beyond what the initial encounter suggested. All of those, I think, really did play a great role in just pushing down the uses of force by SPD.
David, I'm going to hold on your follow-up question if you have one. Ms. Gutierrez has to leave early at about 4:30, so I wanted to make sure that our committee members who had questions for her could ask those questions. So, Zan, I'm going to ask you first what your question is.
Thank you very much. Yes, Dulce, you mentioned how ending something like qualified immunity can have a negative ripple effect for other employment types. I'm wondering if you can provide an example and maybe expand upon that a little bit so that we can clarify our understanding around that.
Yeah. Can you hear me? Okay. So we have, we have tried very hard in the past as part of a labor organization to ensure that there isn't going to be essentially a dismantling of the progress that we've made to try to establish protections across the board for work. So when it comes to public employees and just folks that work for the public, there is a lot that is that's on the line. So we want to ensure that there's workers that are qualified, that care about the public, that don't just see this as just some sort of dead-end job, but that really truly take pride in their day-to-day work as they serve the public for an institution that is really sustained by the public's in the form of revenue and taxes. And so the concern has been that if there is a different standard on one particular department of the city, and if qualified immunity was to be modified to look different or to just not be a part of the contracts in the police departments as police officers are hired, you would essentially open up or crack the door open for this to be something that maybe then down the road is considered for firefighters, and then maybe down the road is considered for, you just begin to open up this door of a double of a double standard of protections for public employees, and that could have lasting implications, whether it be that certain employees either gravitate towards the job description or leave the job. But this kind of goes in hand, and it's kind of hard for me to explain without, I don't know how much time I have here, but if for example, qualified immunity was removed for police officers, you would essentially create an ability for then, the general public to say, well, in Yakima, we have a lot of arson activity, and the fire department can't seem to figure out who's creating fires. So maybe the fire department doesn't do a good job. Maybe they're terrible at their job. And so what if we just don't have qualified immunity for firefighters either? Because they can't seem to solve the problem or reduce the amount of fires that are occurring. And so then all of a sudden now you start to develop, again, a different standard for the protection that a worker has, whether or not that's not going into the discussion on the intent behind any particular action of a city employee or a state employee or just a law official, but really what is the overall protection that a public employee has. And that kind of goes hand in hand with public negotiations between city leadership and, for example, the union that represents police officers. I mean, what happens is sometimes is that you're not able to create a pragmatic way forward or a reasonable way forward. Instead, what happens is you have a lot of decisions being driven by either emotions in the public, by elite leaders of the community who have disproportionate influence over city leadership, city management, mayors. And that can go both ways. It could be that, everybody knows Captain Smith, so we all like him. He couldn't have possibly done that. Or we all know Captain Smith and he's a terrible person and we know he probably did do that misconduct that he's being accused of. I mean, it can go both ways when there isn't some general expectation of protection for workers across the board. If things become different in one area or another, then that can impact all areas of a public entity, whether it be the city or county or state government. And so that's what I meant by establishing a double standard of labor protections. And I specifically used qualified immunity as an example, but it could be anything else. It could be, well, do cops really deserve X, Y, or Z benefits? I mean, when you begin to, minimize or undo some of the protections, labor protections in place, there are other issues that can come up, whether the intention was there or not. And it could undermine some of the labor protections that were hard fought for.
Thank you. Kim, do you have a question?
Yes, thank you, Ms. Gutierrez. Building maybe on that, so you mentioned toward the end of your remarks that, we need a broader conversation, that we need substantive change at the state and federal level, legislation. And I wondered if you had sort of a priority list or an issues that you think are the most important for us to address relating to these issues that we're discussing today.
Yeah, well, I know what like a list would look like for the city of Yakima, but I think every department probably has its differences and its unique challenges and its own unique strengths. One thing that is really important, I think, in a community like ours is far more transparency around misconduct for police, far more there needs to be stricter rules and regulations, I think, from the state or the Department of Justice at the federal level on certain administrative protocols when misconduct is being alleged. And there should never be any allowed, there shouldn't be much flexibility for misconduct to be addressed with an internal investigation. That should be very minimal. In the state of Washington, we just passed a law, the legislature just did, that helps remove, excessive force cases out of its own police department. In Yakima, we did that only after there were multiple incidents of multiple men of color being killed by police officers in very questionable incidents. And so to me, it seems very unjust when, it's like the same police department is finding itself innocent of wrongdoing. And so I'm glad that law passed, but one of the things that becomes difficult is when there is no threshold for body cams. There's no supported mandate. Even if there was a mandate, there's probably no will for there to be funds around body cams and police records that must be kept with body cams as well. So that administrative costs and fees that go into keeping body cams. And yet we have tons of resources for militarization of our police departments. And one thing I noticed, it was that for us in particular, we set up a certain amount of money for training, for example, $400,000 a year. But the police department doesn't have to spend $400,000 a year. They just have up to $400,000 a year that they can use on training. And so, that type of flexibility is a disservice. It's a disservice to the general public, but it's also a disservice to the city leadership, which was very, very resistant to challenging police department protocol. Whether they're candidates only aspiring to be elected, or they're in office and they're either the strong mayor or a council member president or just a council member, it is very difficult for elected officials to take on that challenge. It's almost impossible, and that's why we rarely ever see it. But if there are liabilities that come from a police officer's misconduct, and as a council member or as a mayor, you're married to these police officers and their misconduct, whether they do a good job or a bad job, you have to protect them and have their back. Well, one of the big problems that I witnessed was that even when, as a city leader, you don't agree with the conduct and that conduct was against the protocols or the rules, publicly, you can't really hold them accountable without pretty much putting yourself in a situation where then now the city can be sued and have to shell out a bunch of money. So you're put in a situation where you're either, as a city, defending misconduct by bending all the rules or just making it fit in somehow into the rules, or you're holding accountable a police officer who did something wrong, which most people would know is wrong within city administration, but then you're opening yourself up to a lawsuit, and that comes at the expense of the general funds oftentimes. If it's a huge civil rights lawsuit that is being, that includes in a settlement, and the conversations of a settlement, a change in procedure, then you're dealing with either paying out tons of money or changing a policy and admitting fault even then. So it's very difficult when state laws do not create any sort of balance, do not create any real systemic accountability, do not do at least half the work the city leaders should be doing in holding the city departments accountable, including police accountable. And so the fact that the city is left to be the leaders in this scenario is like, it's like waiting for my grandmother to wash my truck. She's never going to really be able to do that. She doesn't have the ability, the capacity, the physical ability, or the will. And so it becomes very difficult. And I think that that's why the state has to take more action in creating very clear and concise rules around protocol that when allegations of misconduct come up, and they should never be allowed to really be internally investigated. And there should be, far more clarity around the disciplinary action for a police officer instead of allowing that to be so localized. There are things I believe are good localized. Police accountability is not one of them.
Thank you for that. I want to be respectful of your time. Do you have time for one more question?
Sure.
Yes, great. Eric?
this is a question for Ms. Gutierrez and Mr. Holmes, but Mr. Gutierrez, you should only go first since you have to go. You've got a lot of experience over the years dealing with problems of excess force or discrimination, and I'm sure over that period of time have seen a number of things that you thought would have been helpful in preventing those kinds of problems or correcting them when they occurred. Have there been situations where the steps that you thought ought to be taken weren't taken because they had been inconsistent with the collective bargaining agreement, or because you needed to get the union's agreement and the union just didn't agree with what you thought ought to happen?
Yeah, well, in the city of Yakima specifically, just a few years back, we directed the city manager to essentially fire the police chief at the time, and the police chief and the police chief and the police union were working pretty closely together to get the city leadership to overlook some of the mismanagement happening within the police department, including officers that were under disciplinary action but were still, misbehaving or dealing, creating additional problems, and also, management of, the evidence room, quite frankly. And there was a lot of differential treatment amongst the leadership, and even some racially undertoned comments being made by the police chief himself. And so we directed the city manager at the time to start taking steps to fix some of these issues, to work with the police chief, to work with the police union, and create, to clean up that mess that was occurring. A lot can come from a mismanaged evidence room, a lot of bad things. And so, we were really trying our hardest to keep it internal, to work with all the people who were important to be working with, but there was resistance by the police chief, who then brought in the police union, which is really not the way it's supposed to work, but that's how it works in this world. And so they were working together and essentially pressuring city council members to tell the city manager to back off. And they didn't really want to take steps at the pace that they were being pressured to take steps to fix the issue. And so we try to do everything the right way. We try to keep it internal. We try to not embarrass the police chief. And it was because we saw them as part of the city family. And as council members, we value the service that they are able to bring to the community. But we also understood the risks that we're being undertaken by this mismanagement. And so when we took the steps that we thought were most appropriate, and they were the most appropriate, which was to try to address this internally, we were met with resistance and public ridicule. And so it was very difficult to move forward. Now, this led us into a situation where, the city manager began to dig even deeper into the scenario, because it was very odd to us that the police union and the police chief would be working so closely together to resist a change that really should not even be a problem to begin with. And so that's where we discovered, issues like police not clocking off, and a lot of different issues that were coming up at the time administratively. And so we had the police chief essentially fired over a series of documented actions he was taking that he should not have been taking. And that really led to a big, big problem, because then all of a sudden you had the police union and police officers essentially trying to recruit one of their own internally to replace this chief that had been fired. They wanted us to select the person they wanted to be their boss. And the police union really fought for this. They made presentations in front of the city council, in front of public. They wrote letters to the editor. They did all, they pulled out all the stops to essentially argue that, the police union contract prioritized internal promotions, and that there should be a far more transparent and involved process for police officers to be engaged in the community and hiring panels of the police chief. And, to some extent, it was it is implicated in the contract that, there is going to be civil service officers engaged in the hiring process with community panels, community members, and that there should be an intention to promote internally. It just so happened that the police union wanted a captain to be promoted to chief who had a son who has a son still in the department. Now they shouldn't even be in the same department as it stands, because that's nepotism, and since they are in different rankings. But the police union and the police officers at the highest level were pressuring the city to promote this particular individual. Now, this particular individual didn't even apply for the job, and we kept insisting this is a public position, it's a competitive process, you must apply. He didn't apply. So we ended up getting into a very, very difficult, tough situation, all because we were trying to do what was right, which was have a responsibly managed police department. And this is aside of the lawsuits that we dealt with for the killings of different individuals in our community. And when we tried to do the right thing, we were met with so much public resistance that it was almost useless to waste time to do things in the most professional and diplomatic manner. We should have probably just gone straight to making everything as transparent as possible. But again, we tried to do things in good faith, which is what the contract says in negotiations. You try to do things in good faith, and you try to render, the city employees, innocent of fault if things go wrong, and you take responsibility as city leaders and as a city institution. But there is a point where you got to realize when you're being taken advantage of, and when the police is overstepping the protections that were laid out with good intentions for them to have, but to not abuse. And so it was, in Yakima, we've dealt with that, and we've had scenarios where a person was killed by a police officer. This was in my time when we had to settle and pay out the family. But, we've had situations where a police officer has, killed a man sleeping in his car at a 24-hour establishment. And in reality, had that man, before he fell asleep, locked all 4 of his doors, he'd be alive today. And so when you have scenarios like that, you have to ask yourself, was it necessary for that police officer to open the door on the passenger side of the backside of the car, startle a man sleeping, and then kill him because he reacted in a startled manner? No, that is not necessary. It's not necessary for that cop to have done that. And so when you have officers like this and they're able to be back in the field in no time, and then they're acting out, punching people on their front porches, and we're having to pay tens of thousands of dollars to registered gang members because this police officer can't control his temper, and he's already killed somebody. We've already paid out all kinds of money because of their misconduct. You got to start questioning the laws in place that allow for this, because the union is not the one saying this is a good guy. It's not the city manager, it's not the city mayor, it's not the council. It's the laws that allow for these kinds of officers to maintain their positions.
Thank you for your response. We have 2 more committee members who are going to ask questions, and we have about 10 minutes for those questions, just for the speakers to keep that in mind. So we have Tony and then Conrad.
Want me to go first, or?
Yes, yes, please, Tony. Thank you.
Okay. Thank you all panelists. You guys, your knowledge is really just mind blowing. The stuff you presented today I've learned so much. This is for Professor Ford. Again, wow, Professor. What's the main impediment to prevent arbitration from being public? Is it because it's all treated as one big category? Arbitration is for if someone's mad, you shot their dog, or if it's, you do really excessive force, something really bad. What's the impediment to making these things that you see?
Yeah, such a good question. As I was preparing for this, I was thinking, God, I'd like you to see some of my decisions. And so I thought, oh, I'll just send them. And then I looked at great.
Yeah.
And if you guys asked me for them, I think that would be sufficient to allow me not to worry. But part of the rules for my participating on certain arbitrator panels is that I maintain the privacy of those decisions unless the parties agree to allow me to publish them. And so I will tell you, I always forget to ask the parties before I issue the decision. And once you issue the decision, the party that lost isn't going to want you to publish the decision. So I end up in this kind of weird space. Now, so that's thing number one. Change those rules. Make it so, and all you have to do to change those rules, you could talk to the FMCS. You could also create a state or local law that requires those decisions to be public, and that would take care of the ethical issue that I've just raised. That's one way to do it. I think that there's a companion piece. Even once those decisions are allowed to be shared, they should be able to be shared in some kind of predictable and searchable way. And so that just involves allocating resources to, putting all those decisions together in a database that's searchable so that people can see what arbitrators are saying. And that will have a couple of effects. One is to hopefully prevent arbitrators from saying dumb stuff, and also to allow people to see what the course of those decisions is. So I think those are a couple of ideas. If you were to elect to have a public agency be the decision maker in police contexts, then all of that stuff already exists. Those decisions are public. They are maintained in a database. So that's a kind of an easy one-stop shop to get it done. Does that answer your question?
Yeah, pretty much. So is Washington state law or is it bargaining that prevents that public part from happening?
It's weirdly, it's neither. It is the rules that govern arbitrators.
Okay. Thank you.
But you can fix it through state or local law.
That's very interesting. Thank you for that. Conrad, do you have a question for our panelists?
Yes, and I of course would like to thank our esteemed panelists today. I thought it was a great discussion and something that we can really build on both later this week and also in the future and beyond. And so I think my question would be, we'd like to build further on this conversation in the future. So what is one thing that each panelist feels was either not covered or not adequately covered today that should be covered either in our next panel later this week or beyond that?
That is a perfect question. Thank you for that. I'll call on Professor Vaughn to begin to respond, please.
I think, and I'm just going to add, Liz, I think I disagree with you. I think that the public records personnel exemption may make an arbitration decision part of a personnel record and possibly exempt. I'd have to look, but I'm just thinking of the federal in any event. One thing I think I would look into is not the law, but especially listening to Ms. Gutierrez, I think workplace culture and management techniques and how those are really working on the ground.
Thank you. Professor Ford?
I would say, because I'm a kind of a nerd in this area, I think one area that we haven't talked about that much is the scope of bargaining over oversight. And this is an area where at least in Washington, the law has developed in a way that has been uniquely driven by the relationship that Dulce described. That is, that by the police union and police management having aligned interests to resist those oversight schemes. And so we have a series of what I would say are decisions in Washington that are worth taking another look at, and is worth thinking about the scope of bargaining over oversight and perhaps limiting that.
Thank you for that. Mr. Solon.
Yes, thank you very much. I appreciate it. And one thing I would ask, and this is probably open for discussion with everybody that's on the call, is one thing we really haven't touched on, and I briefly mentioned it, but I don't think it was really highlighted, is staffing. In particular, the staffing levels that the city of Seattle finds itself in terms of employees for the Seattle Police Department. And we are approaching losing 300 people. That's a third of the force that could be deployable, lost to deploying for public safety issues. And I think the public safety aspect in terms of crime and increased victimization needs to be spoken of when we're talking about arbitration, discipline, more accountability. I mean, we have to have a robust conversation surrounding the hyper focus of accountability in terms of policing, particularly in Seattle, which we're proud to be partners with the accountability process because we deal with it every day. What are we to do if we continue down the path of these conversations, which I believe hinder the ability to recruit and possibly retain people? Evidence of that is officers fleeing the city in droves due to the lack of political support, due to the hyper focus of more calls for accountability when our elected officials opine that we are that model reformed agency. And I think that's a part of the process, the discussion, if you will, of some of the perception by uniformed officers that want this brought forth in these types of accountability discussions for truthful and honest both sides conversation. I think the biggest takeaway for policing post George Floyd era is, and I speak on behalf of them, is their feeling of almost political betrayal by those elected officials. And I think we need to have an honest discussion. How do we recruit more human beings to do this difficult job of policing, but provide them with basic, reasonable due process protections, or not just collective bargaining issues in terms of the RCW 4156, but more broadly is the encroachment and almost complete collapse of their basic civil rights. And that's the level of feedback I receive on a daily basis. This is why I took this, agreed to take this panel on, and I'm honored to be here, extremely humbled. But we need to have that part of the discussion that police officers were human beings, and crime will always be here. And you're going to need to have somebody to fill the uniform to do the job of policing that it's willing to go after the people that are willing to do harm on our public. So that's one discussion I would like to see here. Thank you.
Thank you for that perspective. And Mr. Holmes.
Thanks. I think this is probably the point where I can be a bit philosophical in that I think the response to a lot of the questions we have here is what do we employ the police to do? I think that what Mr. Solon was saying was question begging. And right now, Seattle is embarked on a reimagining of the police that I just talked about. And the question I have is, will labor law get in the way of that? And, you know, for instance, I think that we're at fault. We as a society are at fault for a lot of the problems we have. One is, I mean, 400 years of institutional racism, right? And calling a cop is not going to fix that. It's not going to fix poverty. It's not going to fix mental health. It's not going to fix substance abuse disorder. It's not going to fix any of those. And so just think about a modest program like Cahoots in Eugene, Oregon. I'm not sure what will be required to implement something like that in Seattle, but obviously we will, of course, have to talk to our union. Is it a body of work that police officers want to insist on pursuing and preserving down to the bargaining table the right to go after someone who is having a psychotic episode in the middle of the street? Or can we actually be allowed to reimagine the police and make sure that we're not sending them into situations where they are not only unable to solve it, but probably bound to fail in a spectacular way? One that's going to create liability for the city, cause harm to the suspect as well as to the officer. I hope that it won't get in the way, but we're probably going to have to talk about body of work, right? That's a mandatory subject. When we talk about discipline, these are frequently mandatory subjects. You know, there's some things that you were talking earlier, Professor Snapper, about, you know, when there's an issue that needs to be pursued at the bargaining table, but political will. Secondary employment in the city of Seattle, we have an opener for it. And I see, as the city's lawyer, tremendous potential for liability if it does not go, if it's not addressed. And yet, we need to bargain these issues. If we get in the way of a city, the community groups, its elected representatives, and all of that, doing their best to try and find out what kind of policing will make us all safer, and we have to hold to the old way of doing things, which have just failed dramatically, then, you know, I would hope that we can find a way forward and still stay and honor labor law. You know, I have a union. My criminal prosecutors are in a union. I believe in unions. I believe in collective bargaining. And at some point, we're going to have to decide how, you know, should unions be back under the NLRA, police unions? I don't know. But is that a way to get standards in place, so that instead of the hodgepodge of police unions across the country, some states don't even allow unions to be organized. But we know that, you know, police unions, they're public employees that are not they're not preempted. They're just simply excluded from the NLRA, and hence it leaves it up to the states. The states can decide whether to grant unions bargaining power or not, and they can put limitations on it where, for instance, municipal liability is at issue. So I'll stop there, but it's an exciting time. I just hope that we can rely on labor experts like you guys to help us find the path forward. Let's define first what policing should look like, and then see how do we get there. Until then, I'm going to insist that the city follow the law, that we bargain in good faith, and that we honor these proposals. You know, we settled the case about body cams in conjunction with this current collective bargaining agreement, but it was ready to go to litigation. We were ready to go the day after this contract was finally signed. And that would have been an interesting juxtaposition of state labor law and body cams and the Fourth Amendment. So we'll have more opportunities. I'm proud that we made great law on the standards of overturning an arbitration decision. That was done internally. Sarah Tilstra, got to throw her name out there, amazing lawyer, and we've made good law. I hope we can also do stuff at the bargaining table. So I'm going to stop.
Thank you so much for that. I did take us a bit into our public comment period because I don't think we have anyone on for public comment. Is that correct, Brooke?
Yes, we only have one member of the public, and they indicated they don't want to make a comment today. So go ahead, Ms. Tierney.
I definitely want to thank all of our panelists. What just a wealth of knowledge and experience and nuanced perspectives. And what a wonderful way to end our hearing, Mr. Holmes, with your comments about really asking us what is the nature of policing today. So thank you for that. I really appreciate you taking your time to spend with us. The transcript and other materials will be available within 30 days following the meeting. If you provide your email address when you joined, we will send you follow-up information regarding how to access those materials. We will also notify you when the committee is meeting for follow-up discussion and when the report will be available. The record will remain open through June 18th, 2021. If anyone would like to submit written comment, please send an email to Brooke Peary at bpery@usccr.gov by June 18th, 2021. And I really want to remind you that we will have one more panel this Wednesday on the role of communities in police accountability, Wednesday, May 19th from 3 o'clock to 5 p.m. So thank you all so much, committee members and panelists especially, and staff. We appreciate all of your support, and we look forward to seeing you all on Wednesday. Thank you for your time. Take care.
All right. Thank you.
Thank you.
Thank you.
Thank you, everyone.
It's my honor. Thanks.